Hello, everybody. Before I start chatting with people, I want to mention a couple of things for those who are coming in on replay crew and for those who come in who don't normally follow this channel. We're going to chat until court starts. We'll chat when it's slow. I need to let people know that I do have a bias on this case. Those of you who have been following me for a while know what that is and how I came to that. In the beginning, I gave Sarah every benefit of the doubt because that's what you do, right? But her pattern of behavior has demonstrated something different. And the evidence says to me that she is guilty. That's what I think. Having said that, it is possible that I could change my mind. If something is presented at trial, if some other evidence comes up or some point is made that I hadn't thought of before, I am willing to consider that. Technically, she is considered innocent unless proven guilty. So there's that. Also, if you're new, I have a whole Sarah Boone playlist. So I'm going to look at chat. Good morning, everybody. It's nice to see you here. This is so much more interesting and engaging when you are here with me. Hi, Sean. Good morning, Wales, UK. Hi, Kathy. Rel says, your bias is safe with us. I felt like I needed to say that because a lot of times I come into trials knowing nothing on purpose because I want to see it the way the jury does. But now I'm in a place where I don't think I'm able to pretend I don't know what I know. I can't really set it aside. Hello, Finland. Small Dane says, this will be so good, finally. Yeah. Yes. Good morning, UK. Good morning, New York City. Boston. Have lots of people here from everywhere. Australia. Diana's listening at work. That's great. Good afternoon, Ireland. Surrey. How's Watson this morning? Doing okay. Doing okay. At lunchtime, and I don't know when that will be. I do want to take a break and have a separate live stream for the afternoon because I need to take Watson out for a walk and provide some quality interaction. It's not fair to Watson for me to ignore her all day long. Good morning, Oklahoma. Goldilocks says, I trust Mr. J and Judge K. Sarah's goons make me nervous. Yeah. Well, she is getting a vigorous defense, that's for sure. And I'm glad she's got lawyers. I'm glad that she has lawyers. Good morning. Oh, Detective, you're from Western Australia. I don't know why I thought you were Canadian. I know there's someone here from Toronto Police. Good morning, upstate New York. Denmark. Nice. Alabama. L. Rush is saying the break is a good idea and I need a break too. Yeah, taking care of Watson and getting some physical exercise is good for my head. So I am going to, nothing's happening yet, but we're still 10 minutes away. Nancy, you canceled your heart echo test for this? Oh my gosh. Your health is more important, you know. L. Rush is saying her defense is disorganized, and if her lawyers talk to the jury or the witnesses the way they do to the judge, the case is already lost. I watched jury selection yesterday, And Mr. Henderson was very personable, completely different person with the jury. And that's really common to see lawyers act one way when they're in front of a judge alone and another way when there's a jury present. And I think the disorganization, my personal opinion, because I don't know, right? My personal opinion is that that's a game. These guys aren't idiots. They're not stupid. They know what they're doing. Hi, the beautiful Bernice. What, Nikki? Why are you saying there's no court? What? Why are you saying that? You're making me nervous. There better be court. Okay. I need to check my email to see if I have some update or something. Sorry, I'm checking. No, okay. No, the prosecutors are in the courtroom. There is court today. It's happening. Okay. Oh, Matuko, you're correcting me. Okay, she said no court over the weekend. Yes, that's correct. Gosh, I got scared for a minute there. I thought, oh no, not again. Frauke says, I always think my night walks with the dogs are always healthy. Yeah. Yep. You're saying you walk where your husband would find you? I have a 95-pound German Shepherd who will not let anybody near me. One time I wiped out. I was goofing around with her and I wiped out on this street and somebody tried to help me and Watson was just standing guard and not letting anybody near me, which can be a concern because if I ever needed a paramedic, that's going to be a problem. Yes, somebody's commenting, I hope audio is better today. Yeah, me too. That's the other thing. I've learned how to change the volume on my mic. So if I need to do that, I don't mind if you let me know. I know that there are some people who troll, but I know that you guys aren't trolling me, so. Castro says, good dog. Yes. Watson is an awesome dog. The beautiful Bernice says, Watson is your knight. Yeah, it's funny at how animals, I think not just dogs, but animals sense things about people. We get socialized to turn off I say trust your gut, right? We get socialized to turn off our instincts. One time there was a guy here, like a repairman type guy. Watson was terrified of this man. And because Watson reacted like that, that was my cue to really pay attention to this guy. It was very interesting. Flowers in the Morning Sun say GSDs make the best security guards. They're great. They're great because they're mushy and snuggly to their owners, but, you know. Criminal Minds, did you train Watson yourself? Yes. And we still do training. So right now we're doing scent training and we're doing tracking and that sort of thing. Still, I mean, we've been training that for a long time. And training the dog yourself helps it helps build your relationship. I wouldn't want someone else to train my dog. Marie, I hope I'm saying your name right. Or is it Mari? Watson will know that you need help and she will let them approach you. I don't know. I don't know. I think they resort to instinct. And yeah, I think too, people think their dogs are going to protect them. But unless you've trained them to, you don't know if they really will or not. Halo One Alina says it's wild how dogs can read people. Yes, because they haven't been taught to turn off their senses. And I get maybe this is a good time to talk about how I always say trust your gut. Some people think that I mean ignore evidence, and that's not what I mean. What I mean is don't ignore yourself. Don't ignore your spidey senses, or if the hair on the back of your neck stands up, or if you get an icky feeling about somebody, or you're feeling like, I feel like this is unsafe, but I have no evidence of that. You know, that feeling will keep you safe. That feeling is telling you, hey, your subconscious is picking up on something here. Pay attention. It means look harder, dig deeper, think more. So it doesn't mean ignore evidence. It means really hone in and pay attention. And then you end up picking up on details that other people might miss. So it's better to be safe. El Rush, yes, I love when you say trust your gut. Frauke says, with my lead dog, I think he could have read if someone wanted to help me or not. He knew more about people than I do. Very interesting. Detective, you're allergic to furry animals? You'd be allergic to my house. My house is a furry animal, no matter how much I vacuum. Matcha, you have a dog named Sable? Got her as a rescue, and she's the most well-trained dog I've ever met. Yeah, don't know why she was put up for adoption. Well, I'm glad you got her. Royson says, I train herders, mostly border collies. Those are smart dogs, border collies. They've done studies on that. Frauke, you were on TV because your dogs were so awesome? That's cool. I'm going to check this. So for some reason, hang on, maybe I'm looking at the wrong thing. I am just going to double check another potential stream here in case what I've got, in case there's something wrong with it. Okay. All right. What? Okay. I've got two potential streams here. So Frauke, I saw your channel. I saw your dogs. Barely Legal Briefs, that's a hilarious name, says, I'm awake, Pop-Tarts are piping hot, juice box full. Hi, Sonia.
Well, good morning to you, and welcome in here on Fox Local. I am Garrett Weimer.
Sorry. Somebody is mentioning Gavin DeBecker. He is one of the people who trained me. I know Gavin personally. So, state of Florida today, Mr. Cacciatore and Mr. J, game on. I'm so glad that this is finally on the road. And somebody said, you know, there's a saying, let the show begin. And somebody said, yeah, let the evidence begin. Frauke's saying you hated being on TV. Filming and being recognized is not for me. Yeah. Yeah, I find it actually weird. It's much easier when I'm talking to you because it's two-way. And I don't tell my friends and family. They know I have a YouTube channel, but I don't tell them where it is. Matcha is asking, is this going to be the actual trial? Yes. Opening statements are expected this morning. I believe, though, they still have to deal with that Richardson hearing, and they may deal with that first before the jury is brought in. And by the way, the Richardson hearing is about a violation, a discovery violation, and that is on the part of the defense, allegedly. PM13 is saying, I have a box of Woodbridge and some ciggies. Ingrid, you had a duck for 12 years? That's interesting. Detective, do I still have the snake oil? A couple of weeks ago, I needed that jar, so I dumped it out. Good morning, California. Oh, PM13 upgraded to the box of Woodbridge, not just the bottles. Great. Oh, L. Rush is saying, yeah, they have to do Richardson and then they need to do jury instructions. They did jury instructions yesterday. They got that out of the way. So the jury should be ready to go. Al is asking, could Owens and co. face sanctions as a result of this hearing? It's possible. Sanctions, it might be as simple as, okay, we're not letting that in. It could be, judicial notice. It could be a lot of things. I don't think anything serious is going to happen, honestly. But I'm not the judge, so who knows? So Tabby Cat Meow is asking if Jeopardy has been established. So Jeopardy is attached because the jury is impaneled. Yep. Buffy's saying, I remember Owens asking for a special mic so he could roam freely in the courtroom. I recall that as well. I don't think he's getting that. I think one of the concerns may be that Boone yaps at him while they're sitting at the table, and the mic could pick that up. Kat's asking, I wonder if Owens will try stepping on Mr. J's opening with lots of objections. Normally, the etiquette is that you don't jump up and object during openings and closings. That's the etiquette. We'll see. Good morning, Catching Crumbs from Texas. Robert, no turning back now for Sarah. She's locked in. That's what you're saying. I don't know. I don't think that plea deal is still on the table, but who knows? True Crime Boozer says, this is like True Crime Oscar night. Kat says, yeah, but Owens isn't normal. True. Detective says, I have my gavel at the ready. Goldilocks says, Owens and etiquette have never met. So I am just going to, it's 9:06. I'm just going to check for updates and see if there's any issue here. No, it looks like it's still going ahead. Oh, apparently there's a large box in the courtroom. I wonder if that's the suitcase. And a wrapped object consistent with a baseball bat. Okay, so what's happening is also that Judge Kranick is taking care of some housekeeping things. So they'll be late. That's why we're late, but it's still going ahead. Barnabas is asking, can we see the courtroom? There's no camera feed yet. So I don't have that. I've been looking around for it because I'd rather show you a picture of that, but I don't have it. Castro Valley Lip says, I think the trial will take maybe twice as long as expected. Who knows? Interesting, though, yesterday, after sidebar, Owens picked up the pace and stopped farting around. So I wonder if the judge said something to him, like, knock it off, pal. Cat Y. Object fest coming. That's a funny way to characterize it. I like that. Gory Dreams. You guys have some interesting handles, I tell you. Gory Dreams says Boone is going to have Owens get into the box and show how safe it is. You guys kill me. Hi, OL Guy Gamer. Scotia Anthony is bringing up a good point. Thank you. Let's all remember self-care. So at lunch, take a break, draw, crochet, all the things you guys listed, whatever it is that helps you get grounded and de-stress. Same with at the end of the day. Late Bloomer says Sarah will do a narrative testimony. Oh, you're saying Trial TV has something? Okay. They kindly, I emailed Trial TV a while back to ask permission to use their stuff. Whoops. And they gave me permission. They were very nice about it. Let me see what I have here. Okay. So, here's what I'm going to do. There. So you can see, now you can see the court seal to see we're still going on. But that means I don't see as many of your comments because I have to look at a different screen now. GB, can prosecutor ask questions after narrative testimony? Yes. Sarah can and will be cross-examined. Hi, Dr. Barry. Saw your comment fly by there. Oh. Yeah, they're having trouble with their feed. Hang on. Okay, here we go. I got to turn on closed captioning. There we go. And all right, game on. Aloha, Peggy. Oil Guy Gamer says, major problem with Sarah's testimony is it could take 3 or 4 days and we still won't know what the story is. I am counting on evidence. In the beginning, I gave Sarah the benefit of the doubt. And now, I don't believe anything that comes out of her mouth. I watch her behavior. I do listen to her words, but I'm looking for leakage, not necessarily counting on her words, the content of her words for the truth. Good morning, Ellie. So I'm counting on evidence. I'm very interested in what the medical examiner says. I'm very curious about the phone that they found in the suitcase, about the paperwork and the syringe. So I did find out that that is correct. You guys were telling me, oh, there's a syringe. And I kept saying, well, I don't know. But yes, it is correct. Shivani says, will the jury be instructed as to why Sarah needs to testify in narrative? No. Good morning, Maine. Tabby Cat Meow says, I just want to know how they're going to make this self-defense. To me, the argument is ludicrous. Thank you, Dolores. First time I saw Owens, he reminded me of Jim Carrey in The Grinch. I didn't get that, but now you know I'm going to be looking for it. Good morning, Mad Mystic. Local Art Witch is asking, what does narrative testimony even mean? So that is when the witness gets on the stand and instead of that lawyer asking questions, the witness just tells the story. And the reason for that is because an officer of the court cannot suborn perjury, which means if the lawyer knows or has good reason to believe that the witness is going to lie, then that lawyer cannot be eliciting that lie, eliciting perjury on the stand. You lose your license for that. But if you're the defense lawyer, you're in a tough spot because you're supposed to be vigorously defending your client and making sure you get certain facts out. So what do? So that solution is to have the witness give a narrative testimony. So they give their story that protects the defense counsel from being accused of suborning perjury. And then the other side can cross-examine. Dr. Barry's pointing out Robert Tellis testified this way and it was a mess. Yeah, it's not good. Katie asked me if I have a smartphone. I do not have data on my phone. And if I'm sitting here looking at my phone, first of all, I can't flip and see it. I need glasses. So, no, it's not going to help me, but thank you. JG says the lawyer will say he didn't know it was a lie, plausible deniability. Yeah, that's something I thought before too. And Kristen is pointing out that it's up to the jury to determine what is fact. Yes. So in a jury trial, the judge is the trier of law. The jury is the trier of fact. The judge makes sure that the law is followed. He's like a referee calling balls and strikes kind of thing. Or an ump. Sorry, I mixed up my metaphor there. And the jury are there who decides how much weight to put on any given piece of evidence, whether or not they think a witness is credible and that sort of thing. So they're the ones to decide Pretty big job. Thank you, Holly's mom. True Crime Boozer says, haha, I know I don't use my phone as much just because I need glasses. Yeah. Frauke says, for sure she is guilty. The question is, guilty of what? Honestly, personally, I think it is much worse than we know about. She is hiding a lot. John is asking, don't you need glasses to read the chat, Lori? I probably should have, but the chat's a little bit far away, the screen I'm looking at, so I can see it better. Cassie's saying their argument is basically, I beat him up and put him in the suitcase, and then when he tried to get out, I had to defend myself. Except that they're leaving out the part where she beat him up. Angel Baby's saying it was a story that made me laugh. Kim is saying, you think that the prosecution might just read the words and not play the video? I think the video is going to come in, unless you're talking about opening or closing statements. Hiya, Julie. It should be starting now, except the judge had to do some housekeeping. Elle is pointing out, trying to live is not an overt act that would create the need for self-defense. Thank you from sunny Winchester, England. Thank you, Nikki. Matcha says did Sarah ever say why she hit him with the bat? And her answer was, yeah, because his hand or his fingers were coming out of the suitcase and she was thinking he could get out. To me, that just shows she intended to keep him in there. Until when? Cassie says, if the defense truly argues this, then you could argue that you could hurt anyone, and if they defend themselves, that means you could use deadly force. Yeah. Local Art Witch says, the video is important, but I wish people would stop replaying it. Yeah, I think so too. Small Dane, I also think she hit him with the bat before putting him in the suitcase. That's what my opinion. But I can't prove that. There's only circumstantial evidence to suggest that. Hello, Spain. Criminal Mind says, I hope the jurors get a packet of chips each and a bag of cookies. Holly's mom, she had maliciously intended to hurt him. Yes. She intended to cause harm, to cause fear, to cause pain. She intended to torture him. And by her own admission now, she intended that he remain in that suitcase. Because by her own admission, she hit him with the bat when he tried to get out. So, Roz says, I think she caught him packing to leave and hit him with the bat. I understand why people would think that. I question why he would be using her suitcase. A couple of people in the chat are pointing out, yeah, it doesn't make sense that she claims she didn't want him to get out, but she left space for him to get out. She also said during one of her police interviews that she was waiting for him to get out to come upstairs and have intimate relations. So that doesn't sound to me like somebody who's terrified. Unhyphenated says, I doubt we'll ever know, but it would be interesting to know how exactly he got into the suitcase. But still, once he was in there, she definitely zipped him up. So there's no question as to whether or not she forcibly confined him. Elle is asking, are we 100% sure it was her suitcase? She talked about that because the lead detective, Chelsea, was asking about that. And it was hers. It was old, and she normally kept it in the back of the closet. Holly's mom is saying, I don't believe it was a game. No, me either. Small Dane says the Richardson hearing will be interesting too. Maybe her lawyer will finally get reprimanded. Yeah, hopefully they didn't have that hearing before this live stream became available. Oh, Criminal Minds. What happens when Sarah tells her story and she can't claim self-defense? Does the defense change their tactics? Well, I think the defense will argue about it. And I think if there is even a hint that she could use self-defense, then it will be allowed in and it will fail spectacularly. Matuko says games that aren't baseball rarely require baseball bats. Really? Yeah. So I think Sarah is once again going to metaphorically shoot herself in the foot because she cannot accept responsibility. She just can't. She can't see herself the way she really is, and she can't handle having others see her that way. That's her big trigger point. Kat saying, I've personally never played hide and seek with a baseball bat. No, me either. Conk is asking if there's a Richardson hearing still. I think there should be. And yes, opening statements, everything's going ahead today as far as I know. Good morning, Chicago. KPM thinks it was premeditated. Oh, Goldilocks has heard that Mr. Torres' family is in the courtroom now. And that, for all of the, I know we laugh. I have a dark, twisted sense of humor because of the work I've done. And it's a way for me to be sort of mentally okay. I know that sounds weird. I think some of you understand that. But when it comes to the victim and the victim's family, as much as I laugh, I'm never laughing at or about them. I'm laughing at Sarah's antics, but they deserve respect. Local Art Witch thinks Sarah must legitimately have some kind of personality disorder. I think so too. I'm not qualified to diagnose though. Nope, not today, says my heart hurts for them. Yeah. A lot of people commented yesterday that when Mr. J read the transcript of what went on in that suitcase video, a lot of people realized after the fact that they were crying. It really, I don't think you can be human and have this not affect you somehow. Amy says, Amy, you have a dark sense of humor too. Yeah. Sometimes I think I have to be careful about where I use my humor. Here we go. Who are the people sitting up on the bench with the judge? What's going on there? Are these law students? Does anybody know? Oh, so Shama, you're saying I have to have a dark sense of humor working in healthcare. Yes. My son works in healthcare. I mean, I think he had a dark sense of humor because of me, even before that. But yeah, it helps. You have to.
Bless you.
Halsey is asking, is that a giant Sarah head? That there, for those listening, there was a big giant picture of Sarah's head. Yes. Scotia is saying, same with social work, dark sense of humor. Yeah. And you'll find that nurses and cops tend to get along. People are in the chat are saying she looks happy.
James Owens on behalf of Sarah Boone.
It's not going to last long. Oh boy, hang on. Can't hear again. I'm gonna.
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person, so we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 as identified in the defendant's fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Your Honor, most of them deal with just billings, observations by the medical personnel, so on, that don't necessarily apply to the issue of anxiety, as the court had indicated. I did include certain pages that discuss depression issues, as I believe that they were related to anxiety. And then I've identified 4 or 5 other pages that are not anxiety related that may be relevant to the case. I've described that for you.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages, the first two that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, 2. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment of January 23rd, 2018 was my understanding.
So they're talking about an assessment at the healthcare center, not an assessment at a police department or something. So she was wanting assistance because she felt depressed and was crying, but she's on a substance that is a depressant. So the prosecution wants to say, look, if you're gonna bring in how depressed she was, you have to include the whole story, which is that she was over twice the legal limit in terms of how much alcohol was in her system. That is relevant, and you can't. There are rules of completeness. I think that it was the judge pointed out, although that isn't really the prosecution's main issue. So,
standing. Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
They just skipped 48, just like they skipped 26.
Okay.
Page 63.
Isn't that interesting? Now I'm going to ask you, is my volume okay for you? Okay. The pages that the defense skipped, conveniently left out, are the ones that show how inebriated she was. And you know, Sarah doesn't want people to think of her as an alcoholic. She doesn't want to admit that she has a problem. So they're doing what Sarah does, which is, I'm going to give you information, but I'm going to leave out other really important information. And I can't help but think that that was done at Sarah's request.
It appears to be repetitive, but we don't have any particular objection to page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018, so we don't object to that. So basically we're asking for pages 26 and 48 to be included.
Okay, thank you. The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State 369 Southern 3rd 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
Judge, I did check with my secretary, Margaret, and my understanding is I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical.
Oh, come on. He doesn't know it's going to be a question about when he sent it out. Of course it's going to be a question. That was part of the issue. And I'm waiting to see if he throws his secretary under the bus.
Release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. And I think it was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital, so we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may, real quickly, based on the invoice that was sent from the Workforce Advance Billing Department, apparently it's a separate subcontractor, the request was made on the 27th of September. I suspect they waited until they received confirmation of payment of $135 for receipt of those, so we received those. So it's all been within a couple of weeks, plus we had the hurricane issue last week, and I think there were issues as to the matter being provided for. I did speak with the state yesterday afternoon after I had a chance to look at the records and advised the senses of these matters or relationship to, and was told that they already had those records and communicated with them. So I don't think there's any prejudice to the state based on our submissions.
Okay. Any further argument or positions with regard to the Richardson analysis, Mr. J?
Yes, for the purposes of this hearing, I'd like the stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Your Honor, there was just a reference that 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was entered as 1, correct?
Yes, sir. It is sub-labeled within these records as page 2 of 14, and it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that, and so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance of those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing.
And this is an example of how sometimes things get into evidence that shouldn't be there, how sometimes attorneys can get blindsided because you've got a disorganized mess and no time, and you're hoping that this other person who is also an officer of the court is being honest, and sometimes they're not. Or you're assuming the other person hasn't made a mistake. So clearly, Mr. J has been working hard, working a lot, and combing through this stuff to make sure. So that is a good sign. That is a good prosecutor.
Look for it again, and I'll provide
Okay.
information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed. So they closed. So we were there at 8 o'clock to get the copy to the state we had promised. But we will bring one at lunch to hand to state.
Okay, appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to...
Kim, I don't know why my audio has an echo. I've moved it closer to me. I don't know what to do about it. And I'm trying to keep my cursor in a place where it keeps the captions up. I'm doing the best I can. I'm sorry. And yes, Al, the excuses. Owens is, I don't know, he has a library full of them.
Let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that sought to be moved into evidence with regard to this January 23, 2018 incident as provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking.
Late Bloomer is asking if the BAC, so the blood alcohol in the documents, is from the day of Sarah's arrest, and the answer is no. They're talking about medical records that the defense wants to put in to show how depressed and upset she was. And the defense had left out those pages that show that even prior to the incident for which she is now in court, her BAC was really high. So the judge ruled that no, it has to be complete. They have to be included. And I'm finding this part interesting, this discussion about opening statements, because Owens wants to do the showman thing. And the state is pointing out, hey, he may be including jury instructions that may not even be given. And that would be inappropriate. It would be confusing to the jury. Owens is going to use the tactics that advertisers use. Repetition, seeing a picture as well as hearing a narrative. So this argument's going to be interesting. I suspect the judge is going to carve it down the middle.
For us to discuss that.
Response before we go through each photo.
Judge, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force.
I'm not discussing the jury instructions at this time.
There are evidence of prior threats or prior events of violence committed under that instruction. Under the self-defense justifiable use.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did pull up a couple of these on the justifiable use of non-deadly force.
That does not answer my question.
I would agree not to use those.
Okay.
The two I'm interested in using and opening is this standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering the verdict. You want me to read it out?
No, I can see it, sir.
And then the other one is a reasonable doubt is not in there. Possible doubt, speculative, imaginary, or forced doubt is the standard instruction on using it.
What's your position with regard to those two, Mr. J?
Judge, it's opening statements. We should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards at opening statements I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started, and then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please?
Looks like Owens wants to cherry pick the law.
Here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction.
Zing!
For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from
Owens is saying, well, this is an excerpt. The judge just finished telling him that the Florida Supreme Court changed it.
Give me a moment. That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
So far, and opening statements haven't even begun. So far, the defense is trying to cherry pick their facts and cherry pick the law. Terrific.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law. You know, that in many ways, we do it where we give them the law at the very end, you know, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
So they're going to go through the photographs. I wonder if they're to scale. I wonder if there's something he may be psychologically trying to do with the photographs, in addition to trying to burn certain things into the memories of the jury and trying to anchor the jury mentally to certain things. Castro's asking, is the jury there? The answer is no, they're not yet. True crime boozer saying, all I know is I don't want to see an enlarged photo of Sarah. Kat is saying, how do they know the photos haven't been altered? Good question. Matcha says, I'm sure he's trying to manipulate the jury. Well, in a way, I guess both sides are trying to at least convince the jury. Somebody's asking if 5 women in the jury is a good thing. I don't know that. I don't know if these days you can really base things on gender as much. Yeah, Elizabeth is saying, I have no issue with an attorney using any legal means to defend a client. Yes. I mean, if any one of us were accused, we would want our attorneys to do absolutely everything within the law possible to defend us. Yeah. Unhyphenated said, you've watched the interrogation videos and the crime scene video, and there were no bruises on Sarah. That is correct. Sarah even stated in her police interrogation, look, there's nothing on me. I have no injuries. And the lead detective said, yeah, exactly. I think people are talking about women versus men on the jury. I think women are, generally speaking, I'm going to be very general because there are exceptions, lots of exceptions, right? I think a lot of women, let me put it this way, a lot of women are less swayed by crocodile tears from another woman or what appears to be hysterics or that sort of thing. I think sometimes women are harder on women. So and some in the chat are talking about one juror has said she suffered from DV. And my personal opinion is, and I'll listen to what you guys say, my personal opinion is that somebody who has suffered from IPV or DV, they know what it's like. They would understand, for example, why a victim might not report, why a victim might not leave. But they also understand that if the perpetrator is in a suitcase, you're not standing there beating him and mocking him. You're not going to go to sleep if you're afraid. Thank you, Kat, by the way. Oh, okay. Yes, thank you for reminding me we can zoom through. I'm afraid I'm going to miss the talking, though. Okay. Yeah, they're talking, but you can't hear a thing. Oh, hang on. What is this?
Custody of the phone. The state had the photographs. The state provided the defense and discovery with these photographs. We intend on introducing these photographs. We don't intend on introducing the blow-ups. We intend on introducing the normal size pages of the photographs and then using these as the demonstrative today to show the jury during opening and then closing the injuries that Sarah Boone sustained.
I think even the subtitles aren't correct.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement? Mr. Owens.
Yes, Sir Judge, and I sent you some cases.
When did you send it, sir?
This morning.
I have not received it.
So once again, Owens says he sent something and the judge has not received it.
I think you were already on the bench, so we sent it to the clerk and the judge.
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it, or a separate one, but I'll check.
This is just these two cases. I've been provided Alsaguer v. State, 326 Southern 3rd, 656, Florida Supreme Court, 2021. Lowe v. State, 259 Southern 3rd, 23, Florida Supreme Court, 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Al-Kagir case, which is the 2021 case, trial court acted within its discretion in preventing state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that wasn't in the record. The 2018 case, Supreme Court of Florida, again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution. The trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound, advising of the trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim's size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. The court allowed, again, the court's discretion. As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from the norm.
He's going to walk around like this during opening statements. It's going to drive us all crazy because we can't hear him.
Because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person.
Thank you, Holly's mom.
Goes on to say, you find at the time of the alleged second-degree murder, Sarah Boone knew that George Torres had committed an act or acts of violence. You may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use an unlawful force. We have a good faith belief that the exhibits will be introduced into evidence. They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes, sir.
Yes, sir.
Judge, the standard is it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established and that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state.
Very clever of Owens, actually. I knew he would try and pull something. And Mr. J is on it. So these photographs are potentially exhibits that could be brought in during the trial to show the prior bad acts by the victim in this case. And showing a photograph of a physical injury is much more impactful than saying, oh, there was a physical injury, right? The problem that Owens has is, although he can bring all this stuff up in opening, he can't actually introduce any of the evidence during trial. And unless Sarah testifies and the foundation is laid. So in knowing that he may not be able to get any of these photos in at all as exhibits, he's just gone and said, oh, I'm going to use them as visual aids during my opening. And that is how he's working around that probability that they won't be allowed in. And Jay's on it and he's going to argue. I hope the judge doesn't allow it. We'll see.
Side is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, then certainly A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things if we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. It's, I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that prior?
No, what I ruled is that you were able to discuss them, you address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense.
Do you see how he changes the argument? Have you ever met someone like this? So first he says, Owens says, oh, but you ruled this would be allowed. And Kranick immediately recognizes the game here. No, we didn't rule that. We agreed you could discuss it. We didn't rule that these exhibits would be coming in. So instead of answering to that remark by the judge, Owens switches tacks and says, well, I didn't mention battered spouse. No, that's not what we're talking about. We're talking about you trying to sneak in currently inadmissible evidence exhibits during your opening statements. That's what we're talking about. But he won't address that. Very frustrating.
In arguing these, I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there is going to be evidence of an overt act. That she was facing imminent threat, and she reacted based on that threat.
Understood. Your response to Exhibit B?
Look at B. Which one's B?
It's her on the back porch with the 2 dogs.
Judge, not only did he abuse, George Torres abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is a part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce that they listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, George Torres, he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
Okay, now I'm ticked. Oh, I am really angry. Okay, what makes people angrier than harming or threatening to harm children and animals? Right? What makes you think that somebody is horrible, a horrible person? So now, all of a sudden, out of nowhere is coming, sorry if I'm yelling, I'm mad, is coming this allegation that the victim abused the dogs or threatened to abuse the dogs to control the victim. I suggest to you that it is Ms. Boone who uses people and other sentient beings in whatever way she sees fit. What a horrible, horrible allegation that is without any foundation. We've never heard this before. Where was all of this during, and she even said, oh, he was sorry, he was dancing with the dog. We were having fun with the dogs. Come on. Oh, I'm mad.
Okay, thank you.
They're checking, Judge.
All right.
On whether they have
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, the purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about This is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be pasted back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific, some incidences may have happened, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we prepared to bring in our jury at this time?
I've got two other issues.
They've been waiting for an hour and 20 minutes, Counselor.
We intend to play the 2-minute suitcase video to the jury in opening statement.
State.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during the opening statement.
What's the other issue, sir?
I need to approach the bench on the other.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. What's good for the goose is good for the gander. I'm not going to allow your photographs, not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you.
I'm going to fast forward past this approach here. See how far we get. Whoops.
Okay, thank you. Can you all approach for a moment?
Are we approaching
And
again?
a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you.
One of the jurors rode in the elevator with the defense counsel. Wow. Sorry, I lost it there a few minutes ago. I'm going to have to go back and when all this is over and see if anybody else was as mad as I was about that.
All right, thank you both for your honesty. I appreciate that. Something we talked about earlier this week. That's the one thing that we required and asked of you is just be open and honest. And I appreciate both y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way to have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. Jay, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him this event. Evidence is going to show George Torres is dead because in this defendant's judgment, he deserved it. And out of a conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah. The defendant will say, "For everything you've done to me." Sarah. "For everything you've done to me." Sarah. "Fuck you." And then the defendant laughs. Sarah. "Fuck you." And the defendant laughs. Sarah. "Stupid." Sarah. "That's my name. Don't wear it out." Sarah. "I can't fucking breathe, baby. Seriously." "Yeah. That's what you do when you choke me." Sarah. 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 The defendant laughs again. Sarah, "I can't breathe, babe." She laughs again. "That's on you." Sarah, "I can't breathe." She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 "I can't breathe, baby." That's what I feel like when you cheat on me. Sarah, "Fuck you." "I can't fucking breathe, Sarah." "You should probably shut the fuck up." Sarah, "Shh," is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound George Torres gets put into this suitcase, left to die? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, Mrs. Torres, and eventually realizes, oh my God, he's in the suitcase. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, he took his little legs out. At some point she makes that statement. And tries to resuscitate him. Hears gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out and gurgling. Then the next thing she does is she doesn't call 911. She calls Brian Boone. Who's Brian Boone? Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. A normal work day for most people. School day for their child that they share in common. But after they got divorced, the arrangement was and that we can include.
I'm sorry, I cannot hear a thing. I'm going to see if I can make... No, I can't make it louder. Rats.
Friday, Saturday, Sunday, so it's that free schedule. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2020 was a Sunday, and now we've led into Monday, Mr. Boone had been trying actually to contact the defendant several times that morning because he just wanted to confirm she was going to get their child after school every day. And there had been a history of reliability issues on that issue on her part. So you will see in the phone record, he calls her and calls her and calls her. And then she finally calls him back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, 10 minutes. And as she's explaining to him what the heck is going on, he peeks in through the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right, but there's a doorway that you can see all the way through. And on the back side of the kitchen in the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside though, being the good co-parent that he has been. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear are tears. What you will not hear is sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake, he's purple, he's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in suspicious deaths, was taken to the 9th District Medical Examiner's office and autopsy. What the doctor found was what you would expect after being left in a suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head, taped shut with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2.
I was hoping to not interrupt opening statements, but it's a struggle hearing him. So in case you didn't hear, he is explaining to the jury that Mr. Torres passed away from a combination of positional asphyxia and environmental suffocation. And he's explaining that to not have enough oxygen, you don't require to like have a bag over your face or something. It just means that you can't get enough oxygen. And that would be because he was confined in the suitcase. And positional asphyxia is when the person is in a position, because Mr. Torres was scrunched up in that suitcase, in a position where the chest can't expand to take in air.
But she also did notice, he suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion, will help her explain contusions and bruises. She'll use words like hematomas, will help her understand for you all that that means bleeding under the skin and blood, what you expect from a bruise, that's why they're running through. But he had all this additional trauma, and he had trauma on his fingers as well. So now, the Sheriff's Office, Orange County Fire Rescue show up, and the defendant interacts with the first patrol officer. You will see and hear that body-worn camera. And it's more of the same of what we heard on the 911 call. Hide and seek. It was good. I fell asleep. I don't know what happened. A few hours later, the detectives from the homicide unit of the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of a counter that was found on a suitcase of Mr. Torres and giving it to one of their digital forensic examiners, who we'll hear from later in the trial. But it's time to give a first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is, we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Boone wasn't even half full, so the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are 750s, 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, so the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoked, did art, listened to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th and 25th. What they are doing, and by they I mean Orange County Sheriff's Office in part, is going to her phone. That's when they discovered the 2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before, though she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her, and you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres' brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Ms. Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces and nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote-unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres. Referring to Mr. Torres. Getting rid of. And that's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey through this case, we're all going to come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim. It is a door we shall not enter without permission and invitation. Halloween is in like 13 days. Part of the vampire lore is vampires can't come get you in your house.
Okay, for those of you who can't hear, I think what he's saying right here is normally the defendant's history is not allowed in, but it's kind of like in vampire movies where if you open the door and invite the vampire in, well, then the door is open. So you get where he's going, right?
Participate during this trial. We're going to be invited in to the defendant's past relationship for the previous couple of years with Mr. Torres. And as we come inside this room, at her beckoning, we are going to high score on his blood alcohol level was a 342 once when he got treated at the hospital. This is a man who had serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date, it's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these days are at bars, and there's nothing wrong with that. And it just typically ends up, she's going to tell you, I suspect, or you're going to.
Okay, I got to talk to you guys for a minute and figure out if I am understanding the same thing you are. It sounds like their first date was really bad, that he hit her. Is that what he just said? And then he's saying, yet she continued to go on a second and third date with them. Is that what he's saying? Caitlin's pointing out, yeah, she cheated on Brian with George. Yeah, actually, that brings up something else. If she'd been beaten up on some first date, Brian would have known it, right? Okay, KPM, you're saying that's what you thought he was saying. Yeah, okay. And Jeff is saying not sure. So Loba's pointing out that Mr. J is saying the defendant is going to allege these things. The jury, you're going to hear this. Okay, I'm just going to keep going.
It's one thing or the other. Like, I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. You're going to hear and potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes, cuts in the face, But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all of us agree that it means these three elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. Gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what.
Okay, he's talking to them saying you might hear about battered spouse, you might hear about from experts. Oh, you're okay. Somebody's telling me Fox Orlando is much better. Okay, I'm going to go see if I can do that. Hang on.
Time, and you might need those alternates.
With what happened on February 23rd. From generation to generation without being right.
Okay.
We hear all of the evidence.
Okay, I'm going to switch streams. I can use it because it is a public video, so I should be able to use it. Gosh, I hope I don't get in trouble for it. Okay. So we're going to try this stream, and if another stream improves, let me know, and I'll switch.
And then apply whether or not these past instances have anything to do with what happened on February 23rd. Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room, labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized. The experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5-DR. Diagnostic Statistical Manual, version 5, and I think it's text revision or something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all of us agree that it means these three elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. It gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between experts, because it's kind of like grandma's recipe handed down from generation to generation without being right. But
I'm sorry, MZ, closed captions are not available on here. You can try, and I don't know if you can try it on your end. I don't know if it'll work there either, but it will not work here. Sorry.
what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over on an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the decedent. You will hear about all this. And what it ties into, at the end of the day, after we talked about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society, but years ago when this was first being researched, the question would be, well, why don't you leave? And battered spouse syndrome and the testimony from these experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, the isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, but turning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get a self-defense instruction as part of that. That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, like a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape. I rewired the entire thing. Brand new JDC pipes. This sucker's good to go. I appraised it at $600,000. You're not going to take that home inspector's report unless they lift the hood, take the tires, do all the things that the Carfax does. You want an expert to get reliable information. And an expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving you the story. Even if it's the patient or the client that is saying all these things happen to her. You gotta find proper information. You gotta check reliability. Particularly in circumstances like we discussed.
Okay, do I need to go to... Oh, boy. I don't know why we lost that stream. Whoops. Crikey. So they're talking about the home inspector. I can at least turn on closed captions here.
The evidence show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances needed. Thank you.
Thank you, Mr. J. Any opening remarks by the defense?
Judge, can we invoke the rule that has been?
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you. You may proceed, sir.
Okay, I'm sorry. I am going to try again. We need something we can actually hear. And I'm going to... Here we go. Let me get something else. Sorry, guys. Let's try this.
With the use of alcohol?
Oh, Paige is asking, what is the rule of sequestration? That means they want... I believe what he's referring to is sequestering... keeping witnesses apart. So witnesses at trial can't come in and listen. If I'm right, they might call that something different in Florida. So I could be wrong on that.
Alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be, towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. In considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that. All the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon, and they come out with one of those larger bottles of the wine, and then of course there's a receipt, and the bottles are in the garbage can. Of course, there obviously is an attraction between the two, and as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, is what this is about. How are disagreements resolved? But George was very jealous of Sarah, and you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money. But they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex, and Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in and going out, and there'll be a receipt for the purchase of that bottle, and then there'll be that bottle will be in the garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows this is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle, or she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. And that's how they move it back and forth. Well, as she comes down the steps, she sees him getting in and settling in the suitcase. So she walks over there, and they see each other, they smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch, and at some point he says, "I can't breathe." Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get out. He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, the suitcase is flipped upside down. The zipper's on the bottom. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, "Sarah." And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from George Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense. You can hear from the medical examiner. She is going to tell you about some bruising on George Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain. But there's some bruising. Sarah's going to explain that to you. Why that happened. What were the circumstances surrounding that? Involving a bat. Her son comes and stays with them from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that George Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate. Sarah loved you. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had no intent to kill. The prosecutor mentioned she wanted him to die. Farthest from the truth. She loved the man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak. Vulnerable. You're going to hear it all. You've got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect. And, you know, she goes, as many of us do when we drink too much, you know, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. Thought he was on the computer looking for a job. She looked outside. Maybe he's out smoking a cigarette. and she sees the suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house, where her son is at, Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. Look, what do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. And she called 911. She calls 911 within a minute, two. Detective Rodriguez arrives. They got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And they know what to do. They try to assess the situation. They start putting the tape out. And then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. They hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs, videos, all that. And they find these two videos. Sarah's not aware. She doesn't remember making the video. You can imagine. She gives them the phone. Of course, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Copsall is her name, Chelsea Copsall. And they end up, Deputy Copsall was pregnant. Or Detective Copsall was pregnant. Said, end up, hey, we're not going to bring your phone. I'm not feeling good. I'm pregnant. Can you come to the sheriff's department? Which Sarah Boone was to tell you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up already. And they were going to confront her and try to get her to confess based on the two videotapes. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon when she got there to get her phone. They said, well, we've got to come up here. We need to talk to you. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand. she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility. And they'll talk about corroborative evidence, other evidence that's consistent with the testimony that Sarah Boone would give you. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack. But it was unconventional. Self-defense nonetheless. Now, as I said, the struggles that occurred, many of them involved the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. The police are there. So her attitude is not one of distress. We're here today, full packed courtroom. Judge Cranit's here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judgment, to keep an open mind, and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of experts. Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty, because it's the right thing to do. Thank you.
All right. I want to talk to you guys. I made notes. All right. Despite not being able to hear the prosecution, I did note that he stressed little fingers coming out of the suitcase and little legs. And the prosecution used Sarah's own words, and Sarah's own words go completely against what she's now claiming. But what bothers me about, or one of the things that I'm not crazy about Mr. J's opening statement, is that he incorporated parts of Sarah's narrative in a manner to make them actually sound true. And one example of that is how Sarah woke up in the morning and went, oh yeah, he's still in the suitcase. That's Sarah's narrative. I mean, I want to see evidence that shows whether or not she was sleeping or if she was up all night and what was going on. So I know he's going through it sort of methodically, and I'm watching the chat to see what you guys are thinking. And the bit about get rid of him, the conversations between Sarah and Mr. Torres' brother, one accusing the father of striking her, and the other one about I'll get rid of him. Now, even if you don't take that literally, even if you don't take that in the worst way possible, it's still getting rid of him. It may mean throwing him out then, but it's still get rid of him. And what the heck was that in the text messages with the hide and seek? So we know she has that in her head. Any comments about that? Mad Mystic is saying, I feel like it could have been better, but he was still convincing. And his style is more methodical. I noticed some people in the chat weren't crazy about his analogy using like a house inspector. I liked it. The owner of the house saying, hey, it's a great house. I'm not going to tell you about the broken foundation, right? So I thought that was okay. Oh, KPM is saying, I think she was hitting on George's brother. I don't know. I want to believe that Mr. J is winning at this point, but I don't know. I'm putting myself, if we knew nothing about this case, try and put yourself in that position. And you hear the opening statement of Mr. J, and it's okay. Like it doesn't all completely paint the picture. Mr. Owens, I think, is doing a good job here. I think he's connecting with the jury, and I'm seeing points at which he's making direct connections with various jurors. He says he admits to the drinking, which is good because he can't get around it. So it's better if you have something bad on your side to just put it out there. So, Jay Borrego says Jay needs to put more emotions in it. Alexander, good point. Defense has a better opening. Prosecution has better facts. And let's hope that the jury grabs on to those. Loba says, I thought Jay missed some facts like Sarah being an aggressor and an alcoholic. And Malcolm Mull is talking about that 11-minute gap. I want to carry on for a minute with Mr. Owens here. So he admits to the negatives so that it doesn't look like he's hiding anything from the jury. So the prosecution can't do a aha gotcha on at least Owens. Also, he's mentioning that Mr. Torres was jealous, that they're going to hear testimony. I want to know who it is that's going to testify to that. Because if it's just Sarah, well, it's Sarah. He spoke about how Sarah knows what's going to happen after they went to Publix for the second time. She knows how it's going to be. Well, you know what? Victims do know. And anyone who knows a victim or has worked in the field or who has been a victim of this knows. They know. They can tell, oh boy, you know, that tension is ratcheting up. I can feel it. I know it's coming. Uh-oh, he's drinking. I know it's coming. So yes, they do know. But Owens has taken this very common thing and made it personal. So it's more relatable. And he says they both weigh around 100 pounds. Records at the time of Sarah's arrest were that she was 140 pounds. He was 103 pounds. Just wanted to point that out. And Owens is saying the key to this case is the 11-minute gap. No, it's not. No. He's doing the same thing or a similar thing that Sarah did, which is hiding the time, which is accepting her story of how he got in there in the first place. I think if they could figure out what happened before he even got in the suitcase, they might have a first degree because of the sudden silence in the middle of a knockdown, drag-out fight and then the crashing down the stairs. So, but the jury doesn't know any of this. So now Owens got it in the jury's head. Oh, we have to pay attention to this 11-minute gap. That's what's important. We need to pay close attention to that. And while they're paying close attention to that, which is not really the crux of the case, they may miss other things. William Carr is saying that the victim's injuries preclude fun and games. Yep. Jenny B said Owens said the suitcase was downstairs all week. That is what Sarah claimed. I think it's going to become clear that that's not the case. Angel Baby says, how many DV victims go around telling people, hey, I'm being abused? Mostly they don't. In fact, they lie about it. She alleged that he hit her because of jealousy in the body cam arrest of 2018, but actually he hit her because she was trying to strangle him. Exactly. So this could be a lot of mudding the waters if it all gets in. Now, this is a long trial, so, you know, the memories of all this may fade, and so we'll see. So, and Owens also said about her phone, making it sound like Sarah just voluntarily gave them the phone, like she wasn't trying to hide anything. Except that's not accurate. Chelsea testified that, excuse me, I'm going to stop using her first name. Detective Copsell testified that the phone was there. She was allowed to seize it. It's evidence. So she seized it. Sarah did sign a consent for them to search the phone. And the fact of the matter is, if Sarah didn't sign that consent, they were going to search it anyway. It was inevitable. So, and Owens coming right out and admitting Sarah was afraid during that interrogation, so she lied. He just covered off all her previous statements by saying she was afraid. She lied. So it looks better coming from Owens rather than the prosecution impeaching her on everything. Owens said, yeah, she lied. She was scared. She was confused. She didn't understand. Yep, she lied. But now she can tell you the truth. And if he can say that he believes her story, she won't have to testify in a narrative. If he's saying he believes her story, he can plausibly deny, any any suggestion that he's suborning perjury. So this is going to be very interesting. I think, and it bothers me that they're doing this with battered spouse, because all of the things that get described when talking about victims, those things are real. Victims don't come forward and report. They do feel shame even though it's not their fault. They do all these things. They're living with trauma, and that does affect your thinking. They minimize all of the things. And when somebody who is a batterer kind of takes that on, and somebody who is falsely, at least at times, falsely accusing, takes on the mantle of, well, I'm the victim and pure and innocent, and he's completely evil, I think it does a disservice to actual victims. Nancy thinks Sarah will have to testify in the narrative. Well, it's going to depend on whether Owens thinks that she's telling the truth. He can argue, I believe she's telling the truth. I'm not suborning perjury, Your Honor. So we'll see. So I'm going to keep going with this.
Thank you, sir. Can the parties approach for a moment?
Okay, I'm going to fast forward past this.
We've been listening to opening arguments in the suit.
If you'd state and spell your name for the record.
And we will wait and see if the first witnesses will be.
Mr. Torres, raise your right hand and be sworn. Please do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, good morning. You could be seated. And once seated, if you'd state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
6 or 7.
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. And Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, I'd say, on a weekly basis.
And how far away did you live from George?
About 5-10 minutes. Pretty close.
Would you see him pretty often?
I would try not to go there too much.
Who was George living with at the time that he passed away?
Wait, Sarah?
And without getting into many details, what was your relationship like with Sarah?
we wouldn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
We were just talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes, sir.
What was she yelling about?
Something about choking or how he choked her. I really don't. That was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it.
Did she sound upset?
She sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
Any cross-examination?
Good morning, sir.
Good morning.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother George Torres, did he ever stay with you at any time?
No.
Would he ever live with you or any of, not you, but any of your other siblings?
No.
All right, sir. Let's go back to this.
Just want to go back and address a couple of things before I forget. The fact that George was calling Juan to check on him says something about George's character. And it sounds like, George is having this normal conversation with his brother, and Sarah is the one screeching, yelling in the background, angry at him, angry before anything has happened during this good day that they were having. I think the defense is going to use that, though, saying, oh, he was yelling about choking her. But, you know, all the yelling effectively caused the conversation to end. And this is part of the head games and the games that these people play, which is to isolate the victim, right? She's going to make it impossible for him to have a conversation with his brother. So now, when Mr. Henderson is asking about the siblings, I'm thinking, oh my gosh, he better not bring up other incidents within the family that have nothing to do with this case. I suspect Mr. J will be on his feet if that's the case. But now Henderson's asking about, did George live with you? And it makes me think they're going to go after the, you know, say, well, what people are like behind closed doors is different. If you didn't live with them, then you don't know. So I think that's where he's going.
This phone call that you were talking about that was on February 23rd of 2020, and that phone call was approximately 7:30. Is that correct?
Yes, sir.
All right. And who called who?
He called me.
And then y'all were talking. Is that correct?
Sir.
All right. And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No, because I knew when he would drink.
Okay. So in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
Now, you said you heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
I can tell in her voice.
You recognized her voice. So you could hear her. Is that correct?
Yes.
All right. And you've heard Sarah speak before that time. Is that correct?
Yes.
And you've heard her speak on the phone before that time. Is that correct?
Yes.
And you said that Sarah was yelling. Is that correct, sir?
Yes.
And she was yelling about, he's choking me. Or tell him about choking me.
Yes.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Not really.
You've heard it before?
No.
Based on Sarah's voice that you've heard,
Sorry. If he hadn't heard it before, I think the defense lawyer was hoping he would say yes. But if he hadn't heard it before, then it begs the question, why then was he not surprised? So I hope Mr. J brings that out, because maybe he's not surprised because she's wackadoodle like that.
was it any indication to you that she had been drinking?
No.
No? Sir, at some point your brother said he had to go, is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have, if I can confirm.
You may, sir.
Sir, other than siblings, do your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
Thank you, sir. No further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
State would call Devin Jamro.
Jamro, that's DEVINJAMRO.
Thank you. You may inquire, sir.
Sir, who'd you work for?
I work for Publix Supermarkets.
And what is your position with Publix Supermarkets?
I am the assistant store manager.
And at what location?
Currently the Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Your Honor, may I approach the witness which has been previously marked for identification as States D and been shown to defense?
D is in Delta?
D is in Delta.
Yes, you may.
Sir, I'm showing you it's been marked for identification as States D. Could you use these scissors and open this and look at the contents of this package to yourself?
Sure.
Sir, do you recognize those items?
I do, yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from your Publix store?
Yep.
Your Honor, at this time I'd like to move what's previously been marked for identification as States D into evidence.
Any objections?
No objection?
What was pre-marked as States D will be received into evidence without objection as States 1.
Your Honor, may I approach the witness who has been previously marked for identification as States J and shown to defense?
You may.
Sir, I'm showing you it's been marked for identification as States J. Can you take a look at that disc?
Yes,
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did, yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes,
And in the normal course of business, are the videos from those surveillance cameras kept?
yes,
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
yes,
And they fairly and accurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
they do, yes.
Your Honor, at this time I'd like to move what's previously been marked for identification, as states J, into evidence.
Any objections?
No objection.
What was pre-marked as states J will be received into evidence without objection as states 2.
And I have no further questions for this witness.
Any cross-examination? Can this witness be released?
Yes.
Thank you, sir. You're released.
Thank you.
Have a great day. State, you may call your next witness.
State would call Joan Williams.
Raise your right hand and raise your hand, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay, Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at the Orange County Sheriff's Office.
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for an emergency, non-emergency, medical, which I transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes.
And those records are made at or near the time of each call, correct?
Yes.
Your Honor, may I approach the witness which has been previously marked for identification as states L and been shown to defense?
You may.
Ma'am, I'm showing you what's been previously marked for identification as states L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
What was pre-marked as states L will be received with no objection as states 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
Right. Can this witness be released?
Yes, Your Honor.
Thank you, ma'am. Can the parties approach momentarily?
Okay, I'm going to try and fast forward past this approach.
Oh, we are.
Can you tell us what it is you do for a living?
After you're seated,
Oh, shoot. Sorry.
Raise your right hand and be sworn. Please be swear or affirm that the testimony you give shall be the truth, full truth, and nothing but the truth, so help you God.
sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Batt.
Sorry.
The
I was
defendant's voice
trying to...
Like, just kind of like, you know,
being so thin, were you neighbors?
January 2019.
And
Okay, sorry. I was trying to turn his volume down, and I accidentally just went way back in the video. I'm an idiot. You can laugh at me. I was trying to not have your ears blasted out. Okay, here we go.
Yeah, that was it. Them.
that's Brandon.
Sorry. Here we go.
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Thank you. Sir, you may inquire.
Good morning, sir.
Good morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Them.
That's Brandon Motes?
Yes.
Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and George Torres?
Yes.
And approximately how long were you neighbors with them?
About a year. A little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for the child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time
It was
was this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like probably 4 to 5 months before that.
So 4 or 5 months before February of 2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like if I do hear anything like through the walls or whatever is out back, just kind of keep my mouth shut. Like, don't really speak about it or anything like that, or say anything to anyone. And I just was like, okay.
Did she make any motions with her hands?
Yeah, like just kind of like, you know, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there.
Yeah, yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake, and it stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Could you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. At the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres' voice?
Yeah, all the time. It was like a back and forth. Yeah.
So, other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument?
No.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, you know. Then it was just like a loud rumbling noise, like that literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Now, was your
Do you think it's clear to the jury that what he's describing is something coming down a set of stairs? Because I didn't hear him say stairs.
bedroom, where was it located in your apartment?
The back of the apartment, so it was like there's like a little kick out next to my patio, and that's like that was my bedroom back there, like along the grass back there.
On the first floor?
On the first floor, yeah.
I have no further questions.
Okay. Any cross-examination?
Mr. Cagley, good morning.
Good morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year?
Yes, sir.
Are you aware that the police were called to their residence?
Like,
while you were there for the year, are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had had other neighbors in the complex tell me that It has been on multiple occasions, so that's why.
Just instead of what somebody else told you,
Yeah.
just what you would observe. Did you ever, the year that you were there living next to them,
Yeah.
were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
All right. And did you work odd hours or you went?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first, please.
Do you know, from your experience with Sarah Boone and your experience with George Torres, that they drank alcohol?
Yeah.
Hang on.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you. Hold on.
Yes, sir, of course.
Now, Vincent, I think you had testified, you may have given a statement to law enforcement,
Yes, it was one of the detectives.
a recorded statement?
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time, yeah.
I believe you had said that,
I'm going to object as to improper impeachment.
Approach.
This is one of the things that happens when you know so much about the case.
The lawyers have approached the bench discussing their legal issue with the.
When you know so much about the case, you hear the witness describe it, you know that the thud was down the stairs.
All right, sir, you are released, not subject to recall. Have a great day. Thank you.
Damn it. You know that it came down the stairs, but that is not actually what the witness says. So, if you know all about the case, you're hearing it and say, okay, yeah, we got that part in. And it's so easy to miss. Meanwhile, the jury isn't getting, the suitcase came down the stairs. So, oh my gosh. So this makes me worried. And they didn't bring out the fact that there was a huge fight and then silence, shuffling, then the big noise down the stairs. So that was a key thing for me when I was analyzing this. Oh my gosh. Okay, I'm going to fast forward.
Thank you, sir. You can be seated. State and spell your name for the record for us.
Yeah, my name is Brandon Moats, BrandonMoats.
Thank you. Mr. Cacciatore, you may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
Please don't put spoilers in the chat if you're a little bit ahead of us.
And so, when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021, 2022.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Battaglia.
And during that time, what were you doing?
Like,
as far as work and school? And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with George Torres in this case?
Honestly, I avoided them as much as possible usually.
The apartment where you live.
I'm sorry. I'm ticked off now. All right. So this one's saying he avoided them as much as possible, which is consistent with what he said before. This is consistent with what he told police. What didn't come up, what did not come up, is the interactions between Vincent and George and how he's an artist, and they talked, and he seemed, the characterization of Mr. Torres by Vincent in the police interviews was that he seemed like a good guy. He was an artist in his own right and all this other stuff. So that humanization of George doesn't come out. I'm getting frustrated.
Tell us, how would you describe the walls that separated the units?
Yeah, I remember that my bedroom was like the front-facing bedroom, and our walls shared a wall with where their staircase was. So, like, the way the apartments were laid out, we had a one-story apartment, they had a two-story apartment. So they had a staircase running right next to the walls next to, like, our bedrooms.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin, so if people were yelling, you could definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued very, very often.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock that evening, probably. Like earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that we can paint the picture, where would that would it have been, on the first floor or the second floor?
We had a first floor apartment.
Okay, so all the units were, or all the bedrooms were on the first floor.
Yeah, like I was saying before, we had a one-story apartment, and then they next door had like a two-story townhouse, so we only had the one floor.
Understood. And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, at literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling, and then it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me like it was falling down the stairs.
Did this affect the walls that were between your two apartments?
Oh yeah, me and my roommate, I remember me and my roommate talking the next day about like we could literally, like, it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, I never saw her after that happened.
No further questions.
Any cross-examination?
Good afternoon, sir.
Good afternoon.
Sir, you were asked by the state if you ever had any interactions with Sarah Boone or George Torres. Is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yeah, I don't like drunk people, and they were drunk a lot, so I did not interact with them.
Okay. Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah?
I would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019, when you woke up and witnessed Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I saw her.
Okay. So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay, thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school and she was trying to talk to you and she seemed paranoid and rambling? And
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many details of what she was saying, because I didn't want to talk to her. But yeah.
Okay. Do you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what she was saying, but the vibe she was giving off was that she didn't want to go home.
Now I believe, and I just want to make sure that I heard you. You said that the first arguments, other than the boom, which was 10-something, initially it was around 7 p.m. You heard arguing?
It would have, because it would have been.
Did you hear what he just did? So this witness described arguing starting at around 10 o'clock. Then they go on and he eventually describes the boom and the coming down the stairs. This lawyer just rephrased his testimony incorrectly and said, oh, except for the boom you heard coming down the stairs at 10 p.m. That is not what was testified to. Don't like it when they do that.
I remember that day I got home from class around 5, because I got out of class around 4:30 usually and walked home, so I would have gotten home around 5:30, and it would have been after because I came home, I made myself lunch, and I took a shower, and then I heard all of their arguing, so it would have been about an hour and a half, 2 hours after I got home, so around 7 to 8 o'clock.
And during that time, when you say arguing, was it back and forth?
Honestly, I wouldn't really be able to say if it was back and forth. I don't know I wouldn't remember too vividly if it was back and forth. Or if it was
Let me
just
ask you
one
this:
person
Did you hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice?
Yes.
Okay. Were they both loud?
Yes.
Okay. If I can confirm, Judge.
Yes, sir, of course.
Thank you, sir. I have no further questions.
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Subject to recall, Judge.
All right, sir, you're released subject to recall. Thank you. Can the parties approach?
Addie's telling me not to get
All
too
right, we have now
frustrated
heard
yet.
testimony from.
Are here no later than 2 p.m. Applies whether you are in the courthouse, at home, or anywhere else. You must not messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information.
Okay,
was
that
the very
is. I
end
gotta.
of his
Oops.
opening argument there.
I gotta
In
get out of
another
this.
portion, he talks
Sorry,
about.
I can't air this because I'll get in trouble for that for sure. Okay, I'm just. Whoop. Leave it. Actually, I won't. I'll go to webcam. It is. Did you hear what time he said to come back? Because I didn't. I'm gonna go check here. I'm gonna check and see what time they're coming back. Lunch, then. Oh. 2 p.m. Okay, thank you. Thank you. Okay. So it is 12:39. Ooh, I could walk Watson. So I just want to check with the chat and see if you guys have anything that you want to say. CB saying, yeah, I'm nervous. There's still lots to go. Lots to go. Thank you, Addie. I will kiss Watson for you. Yes, it was Fox that had the good audio. Jay-Z is saying, I don't like how this is going so far. I'm really, I don't know, maybe the prosecution is going to focus on something else. The thing that really clinched it for me was hearing Vincent's interview and that silence in the middle of a fight. So I'm glad it was clarified that the bang was coming down the stairs. And also, Paige, I don't think that there is a rule that if there's an objection that they must cite case law. I think what they're doing is that they must cite grounds, which is a different thing. Loba's saying, I think they could have got more from the witnesses. Yeah, I think so. True crime boozers underwhelmed by the state. Rosie saying, don't be nervous. All trials have ups and downs. It's going to be a long couple of weeks. Yes. Mr. J seems sort of more methodical. And the heart machine is saying both sides are missing opportunities. I think so far, if I'm sitting on the jury and I'm hearing this, you could argue this set of facts in two different ways if you don't know anything else, right? Kimberly is on the wine bottles were large ones, not regular bottles. Loba's saying the timeline is not very clear. No, it's not. And that can be hard at a trial. If I do a video, I can make a timeline for you and set it out and say, hey, here's the timeline I'm telling you, and here's all the evidence of that. They can do that in closing statements. But throughout the trial, if the prosecution or the defense, for that matter, says, here's the timeline, they can't be testifying to it. So they have to kind of bring it out and then tie it up for the jury. No problem, Jackie. I see your comment. It's okay. Addie is saying that you feel optimistic because Sarah's a mess. I don't think Sarah's lawyers are idiots. I do not think that. Nancy is asking, can they call the same witnesses back again? So this is actually something I wanted to mention and forgot. So they're saying subject to recall. So normally when they release a witness, you're done. You're not under subpoena anymore. If you wanted to stay and watch the rest of the trial, you could. Or most witnesses just don't want that and they go about their business. But here, when they're saying subject to recall, it's because if battered spouse can come in, then they can get these witnesses back and ask questions related to that defense. But they can't ask those questions right now because the foundation has not yet been set out. Mad Mystic is wondering who those people are sitting by Judge Kranick. I don't know. My guess would be that they're law students. Romeo says, you like the last witness? Especially when he mentioned the stairs. Yeah, I was getting worked up about the stairs. That's right. Juan and Brendan were not completely released as witnesses. So far, they're saying subject to recall, so they're not released. Pretend Judge says Mr. J is doing great. He's already dropped a bombshell about 2 new text messages. This is the very beginning. Things will heat up. I do expect things to heat up. Yes, it is very early. But, I see some detail and I get all worked up. Oh my gosh, you need to see this. Right? The CB says that video better sink her. Linda is not impressed with the prosecution. And Addie is saying, yeah, Mr. J has a lot to get in. It's probably building something we can't fully see yet. Yes, that happens a lot. And I think, West Rucker is saying, I think the prosecution knocked it out of the park with the opening statement. All the defense could do after that was damage control. I think he did do a good job. I think his style is very different from Mr. Owens, and that is not a knock against either attorney. People have different styles. Mr. Owens has this, hey, folks kind of style in front of the jury. Mr. Henderson did really well in being personable and making the jurors laugh and being likable during jury selection. And you got to remember that normally we don't see everything that goes on with jury selection. So these lawyers kind of have a bead on who their jurors are and what they're likely to respond to, and they will use those things. Purbug is saying, will the jury see photos of his injuries? Yes. Jessica, it seems like the prosecution isn't asking enough questions. So me, I work up over a detail that I want clarified. But in general, the prosecution, both sides have to be careful, because if they open a door, then the other side can walk through that door. So I think a lot of things are going to be sort of subdued until Sarah takes the stand. And then all HE double hockey sticks is going to break loose after that. I think it's got to be that way. Rosie didn't think Henderson was personable, so difference of opinion, which is perfectly okay. William Carl says, I hate to procrastinate, but we'll make an exception here. Been waiting for 4 years for this trial. Addie, I hope George's family is okay. Yes, they are in court, and they cannot listen to the testimony of the other witnesses. They had to leave the room when the trial started. So, yeah, I can't imagine being in their shoes. It's got to be really tough. Okay. I think. Oh, Linlin is saying there might have been an issue with Vincent's interview versus his testimony. Oh, as we heard the objection to improper impeachment. Yeah. Yeah, I don't know what the Did I lose my stream? I'm not sure if I'm live. Whoops. Okay. I lost my stream for a minute. So we don't know. I don't think there was any huge issue. So something's going on with the computer here. So I'm going to end the stream and take Watson for a walk. I will see you guys at 2 p.m. Please eat something. Take care of yourselves. Find something to laugh about. And I will see you at 2 p.m. Thank you for hanging with me. You guys make it all so much better. I really appreciate you hanging and chatting. Trust your gut. I'll see you in an hour or so.